Do I qualify for bankruptcy, and how long does it take? Michael was a physician. He was juggling payments to his ex-wife, the IRS, as well as significant credit card debt incurred helping educate his kids. He had a good income, but the interest and penalties on the debt were significant, and he was left with little for living expenses. He was able to file Chapter 13 and stop all the interest and penalties. He was then able to pay off the debt he owed. Almost everyone qualifies for some type of bankruptcy, whether it is Chapter 7 or Chapter 13. A Chapter 7 is a liquidation where all debts are wiped out with few exceptions, student loans especially. And Chapter 13 is considered a reorganization bankruptcy, where you pay some or all of your debts back over time. Two factors will determine which chapter you file. The first is the assets you have and whether they are exempt. The second qualification is analyzing whether your family is above or below medium income. All income sources are included in this analysis, including rent that you might receive from a family member. In 2005, the bankruptcy laws were amended, following all the efforts from the credit card industry to pressure individuals making a certain annual income to pay some or all of their creditors back in Chapter 13. Congress amended the code to include the means test, which, depending on your state you live in and your family size, will determine whether or not you qualify for Chapter 7. Connecticut has one of the highest medium incomes in the country. The median income for a single person in 2019 is $65,117. The median income for a family of two is $83,597. And the median income for a family of four is $116,897. It changes every quarter. Occasionally, even if you're above the median income, you can still qualify for Chapter 7 if you have a greater than average deduction, such as union dues, health insurance, a higher than average mortgage, or auto payment. These deductions would allow you to offset some of that additional income. In determining whether or not you qualify for Chapter 7 bankruptcy, there are other factors that should be considered. If someone has recently died in your family and you are due to get an inheritance, the money you're going to inherit could go to pay your creditors. Also, a personal injury might not be fully exempt from creditors in a Chapter 7 bankruptcy. Additionally, you're only liable, or able, I should say, to file bankruptcy under the Chapter 7 every 8 years after receiving your last discharge, while a Chapter 13 allows you to file every 4 years. This law was changed in 2005. At the outset, your attorney will calculate the means test and perform an analysis of your assets and exemptions. Then you'll take credit counseling. Once you've made your final decision, you are ready to complete the process. A bankruptcy petition, schedule, and statement of financial affairs are filed with the court. After you file your bankruptcy, you will have to appear for what's commonly called a meeting of creditors, or a 341 meeting. It will generally be held within an hour's drive from where you live. Prior to the hearing, your attorney will provide the trustee with pay stubs, tax returns, and other documents. The 341 hearings are conducted by the trustee, who will ask you if you've listed all your assets, if you listed all your liabilities on the schedules in your petition, whether the schedules that you filed are true and accurate at the time you filed for bankruptcy, and whether everything is basically in order and true and correct. If you've forgotten or deliberately failed to list all of your real estate assets, chances are the trustee would have done his search and already know that. If you've listed all your assets and your liabilities and your assets are exempt, the trustee will close out your case and file a no asset report with the court. By law, you're not entitled to receive a discharge for 60 days after your 341 hearing. The 60-day period is generally for any creditors to object to your discharge. This rarely happens unless you've abused your credit cards prior to filing. After 60 days, the bankruptcy clerk will mail you an order of discharge. This is endorsed by the judge and states that your debts have been discharged. There are not tax consequences to receiving a discharge in bankruptcy, unlike a debt being written off by a creditor. Furthermore, the whole process from start to finish will have taken approximately 90 days. If you file for Chapter 13, the bankruptcy process takes a little longer. The initial phase of filing, meeting with the trustee and resolving any objections with the trustee and creditors, takes approximately 6 months. Another prerequisite of filing a bankruptcy is to determine whether or not you've transferred any property in the last 4 years, or in the last 10 years if it is a self-settled trust. Many people run into trouble with creditors and start transferring property to a spouse or a family member, and they transfer it for less than actual value, so it is outside the reach of creditors. The bankruptcy laws frown on these types of transfers. They're considered civilly fraudulent and can be voided for the benefit of creditors. When you meet with your bankruptcy attorney, you'll want to make sure to tell him or her of any transactions you made in the last few years or to yourself under another entity. They may be able to fix this and solve a problem for you.